And I'd like to start out by thanking Derek Yonai and Florida Southern College and the other organization that sponsored this event, and all of you for coming. I'd also like to thank the Supreme Court for deciding the Kelo case, because although I think they got it badly wrong, it was really good for me and other people who study this area. I got a whole bunch of articles out of it. It helped me get tenure, and now I've managed to publish this book. So although this was bad for the public interest, it was really good for legal scholars who study takings and public use. So to the extent that the Supreme Court listens to me, which is not very often, my message to them is to keep up the bad work. Because the more bad work they do, the more opportunities there are for people like me. So in this presentation, I'm going to start out by briefly talking about the history and origins of the Kelo decision, where the Supreme Court decided that it was permissible under the Constitution for the government to take private property from one private individual and give it to another one, simply on the basis that doing so might promote economic development or promote economic growth in a community in some sense, even if they didn't necessarily have proof that the supposed development is actually going to materialize. And so in the first part of the talk, I'll discuss a little about the history and origin of the case and how it got to the Supreme Court. Then I'll shift to discussing why it was that the Supreme Court got this wrong from the standpoint of both originalist approaches to constitutional interpretation and also living constitution ones which hold that our understanding of the Constitution can legitimately change over time in various ways. I'll then go on to discuss somewhat the real-world effects of these sorts of takings, both the economic development condemnations that were at issue in the Kelo case itself, and also the closely related blight condemnations. Some scholars have said it's true these sorts of takings, they may cause harm, they may be abused, but we don't want to ban them entirely. What we want to do is have partial reforms to mitigate some of the problems that might arise from them. I'm going to suggest that while these partial reforms, some of them may have value, they're not as good and not as desirable as categorically banning these sorts of condemnations entirely. Finally, I'll talk somewhat about the dramatic and massive political reaction generated by the Kelo case, which in many ways was unprecedented. Most Supreme Court decisions, only experts like me or people who are directly affected pay attention to them. This one was a huge exception to that pattern. It really riled up public opinion throughout the country in a way that rarely happens. So first things first, how did the Kelo case even originate in the first place? How did this case become a national sensation? It first began with somewhat unlikely origins in the small city of New London, Connecticut, which in the late 1990s had fallen upon difficult economic times, and city officials hoped to revitalize the community, including the Fort Trumbull neighborhood, where they wanted to do a development project in conjunction with Pfizer Incorporated, a major pharmaceutical manufacturer that had recently planned to open up a headquarters nearby. In part because of lobbying by Pfizer, they decided that they wanted to build a whole bunch of facilities such as office buildings, hotels, high-income housing and the like that would work in conjunction with the Pfizer project and that Pfizer wanted. But in order to build all these wonderful things, they needed, or at least they thought they needed, to take about 90 or more, mostly residential properties in the area. And so they obtained the power of eminent domain, the power to take those properties by force if the people didn't consent. Most of the property owners in the area did in fact consent, quote-unquote, voluntarily, though actually under the pressure of eminent domain and also under the pressure of various kinds of extra-legal harassment that I talk about in my book and can talk about in questions. But a total of 7 owners who between them owned 15 residential properties in the area, they decided to resist and they challenged the case in court. They argued that this was unconstitutional because the Constitution, both the federal Constitution and the Fifth Amendment and the Connecticut State Constitution, they both say that the government can only take private property if it is for a public use. And the owner said, there is no public use here. What you're doing is you're transferring property from one private owner to another, and it's just a private taking. It's not for a public use. The case made its way through the Connecticut courts, and ultimately the takings were all upheld in a very closely divided 4-3 decision by the state Supreme Court. Then, to the surprise of most experts, myself included, the federal Supreme Court agreed to hear the case. I say this was surprising. The reason why it was is because the court had already decided in cases going back to the 1950s, in a 1954 decision of Berman versus Parker, where they ruled that a public use can be virtually anything that the government says it is. It doesn't matter if the new owner of the condemned property is a private owner, so long as there might be some potential benefit to the public of some kind. Nonetheless, the court did decide to hear Kelo, even though they refused to hear the vast majority of the cases that come before them. They just say leave them to the lower courts. But here they did hear it, and eventually they did get the result that most experts expected, which is that the taking was upheld. But it was upheld in a very close 5-4 decision. The majority did reaffirm the doctrine that a public use can be almost anything that the government says it is. They said almost any potential public benefit can be a public use, and indeed that the government didn't even have to prove that the supposed public benefit would actually materialize. So in this case, they didn't need to prove that the economic development was actually going to happen. However, to the surprise of many people, there was a strong dissent by 4 of the 9 justices, including an opinion written by Justice Sandra Day O'Connor, a key moderate on the court, and another strong opinion written by Justice Clarence Thomas. So this was a very close 5-4 division, and right away, the fact that it was so close undermined the perception that most experts had had beforehand, which was that this issue of public use was settled. We decided a long time ago, there isn't really much room for debate here. When you get a very close 5-4 decision like this, that's no longer true. Before Kelo, people like myself who favor a narrow approach to public use, they could easily be dismissed as weird ideological extremists or just as people who are just ignoramuses when it comes to constitutional law. After Kelo, you could no longer say things like that. If the Supreme Court is divided 5-4 over an issue, and you have the quintessential moderate Justice O'Connor on your side, then you can't really be dismissed as an extremist. You could still be wrong, but you're not an extremist. So right away, the immediate result of Kelo was to break the seeming consensus that had existed over this issue and to make the subject open for debate within the legal community yet again. Before moving on to the broader effects of Kelo on the country as a whole, the debate that resulted, I'd like to briefly discuss what happened in Connecticut itself in the city of New London as a result of this case. This is Suzette Kelo's famous Little Pink House, which became a nationally known symbol of the case. This is what it looked like before it was taken in 2004. It was one of the 15 properties that was condemned. This is what the same property, the same area looks like today. You can see that no economic development has actually occurred. Indeed, they haven't even cleared away some of the rubble left over from the foundations of Mrs. Kelo's house. And this occurred because this was a badly conceived development project from the get-go. It was badly planned. It was in trouble even before the Supreme Court issued its ruling. And so in the aftermath, nothing was ever built. The plan fell apart, and some other subsequent plans fell apart as well. It is an extreme case to have one of these takings where nothing is built at all, but as I'll discuss later, it's not at all unusual to have takings where the value that is destroyed is actually much greater than what is created afterwards. There are systematic incentives which unfortunately often lead to results like this. Now I should note something that isn't in the book because it was declared just after the book was published. It turns out that there is now a plan to use some of the condemned land to build a memorial park in honor of victims of eminent domain. When and if this happens, this will be development of a sort, but obviously not the kind or the scale of development that was promised to the people of New London by those who promoted this project in the first place. However, in the meantime, it would be wrong to say that nobody has benefited from the Kelo takings because a colony of feral cats has taken up residence on the site, and they have been the only regular users of it over the last few years. If you walk the site as I did, The only structures that you will see are some improvised cat shelters that nice people have put up so that the cats can take shelter from the harsh New England climate, particularly in the winter when there are hurricanes or other events of this sort. So there are beneficiaries of the kilo taking, but on balance, it has to be said that this really wasn't worth it. There are cheaper, easier, and more humane ways to build a feral cat shelter than the one that was pursued in this case. So I'd like to now stand back from the immediate events in New London itself and talk about why it is that the Kelo decision is actually wrong from a constitutional law point of view. The fact that the decision had some bad effects doesn't automatically in itself prove that it was wrong. Many things might be constitutional that are still bad policy or harmful to society. So I'll start out by talking about why this is wrong from the standpoint of originalism, the school of thought which says that we should interpret the Constitution as it was understood at the time that it was enacted. As I suggested before, there has been a debate over the meaning of public use. This debate dates back almost all the way to the 1790s when the Bill of Rights, including the Fifth Amendment and the Takings Clause, first became part of the Constitution. On the one hand, you have the advocates of the broad approach to public use, similar to what occurred, what was adopted in Kelo itself, the idea that public use can be pretty much anything the government says it is, anything that might benefit the public in some way. On the other hand, there is the narrow approach to public use, which says that a public use only exists if the condemned property is perhaps used for a publicly owned project, such as a road or a bridge or other public infrastructure, or if it is going to have a new private owner, that private owner must be a public utility or some other entity that has a legal duty to serve the entire public, so that the entire public gets to use it, as opposed to a more conventional private business where that definitely isn't the case. So if you look back historically, there has always been advocates of both of these views. None of these views ever commanded an absolute 100% consensus. But if you look at the dominant view in the 1790s, most jurists, legal theorists, and others who followed this issue during the era, they believe in something closer resembling the narrow approach to public use. Indeed, they thought that takings that transfer property from A and give it to B, a famous phrase that dates back to this era, that those are violations of the natural law of property rights and also inconsistent with the idea of public use. This was clearly the dominant view at the time of the founding, though I have to admit in this era there was only a limited amount of discussion of this issue because at this time the public use clause, the Bill of Rights as a whole, only applied against the federal government, not against the states, and so there are actually very few takings that implicated the Fifth Amendment of the federal Constitution because it was very rare for the federal government to exercise the power of eminent domain. Even today, the overwhelming majority of takings are by state governments. Now, many scholars believe that if you want to look at the original meaning of the Bill of Rights as applied against state governments, the meaning that matters is not the one that was in place in 1791 when the Bill of Rights was first adopted, but rather that which was understood in 1868 when the 14th Amendment was enacted, and it's because of the 14th Amendment that the Bill of Rights first began to apply against state governments as opposed to only the federal government. So many originalist scholars and judges therefore believe that the true original meaning of the Bill of Rights as applied to state governments is that which existed in 1868. And by this period, we have a lot more evidence on the understanding of public use, because by that time, numerous state Supreme Courts had ruled on the meaning of public use under their state constitutions. Then as now, almost every state had a state constitutional public use clause that had the same or very similar wording to the federal one. And while there was disagreement among the state Supreme Courts, the clear majority of them supported the narrow definition of public use during this period. And the same thing was true of other sources that we might look to understand what people understood public use to mean during this period. For example, legal treatises on property law and constitutional law, they consistently, most of them endorsed the narrow definition of public use. during this period, obviously they didn't have the internet, they didn't have Westlaw or Lexis, so for most people, if they wanted to understand the meaning of legal terminology, such as public use, they would look to these legal treatises that were much more influential during that period than they might be today, and these treatise writers, most of them pretty consistently advocated a narrow approach to public use rather than a broad one. Now, of course, not everybody is an originalist. Many people are believers in living constitution theory, the idea that for a variety of reasons we might want to change our interpretation of the Constitution over time so as to adjust to changing social, political, or economic conditions. In the book, I go through many different versions of living constitution theory and explain why most, if not all of them, cut against the result in Kelo. Here, I'll just mention one particularly prominent one, the idea that what we should be trying to accomplish with judicial review is protecting those people who cannot protect themselves in the political process. The so-called discrete and insular minorities that the Supreme Court famously referred to in the Caroline Products case. If this is your view of what judicial review should be doing, then it turns out that Kelo was a terrible decision because the people who tend to get victimized by these takings are disproportionately the poor, the politically weak, often racial minorities, whereas the people who benefit are generally politically powerful and influential people. So you get situations like this involving Donald Trump, who in the 1990s famously successfully lobbied the city of Atlantic City to condemn an old ladies' and old widows' home so that he could use it as a parking lot for one of his casinos. Obviously, Donald Trump is a much more politically influential person than Vera Koking, and it's not surprising that Trump prevailed in the political process quite easily, though ultimately the taking was overturned by a court. But as far as the political process was concerned, there was just no contest between Trump and his victims in this case, and the same thing is true in most of these other cases. Indeed, in some ways, the victims of these uses of eminent domain are even worse off and even more politically powerless than the discrete and insular minorities we typically think of as being associated with this theory. Most of those other groups, they at least can vote at the ballot box to try to vote out the politicians and officials who did this to them or who did various harmful things against their interests. But if your home is condemned or your businesses, often you end up being forced out of the community entirely. You have to move somewhere else, and then you're not even around at the next election to be able to try to vote against the politicians who took your house and gave it to Donald Trump or to whatever other influential interest group was involved here. So I think there is therefore a powerful case against Kelo under living constitution theory. There are also, I think, a number of flaws in the Kelo decision that should trouble you, regardless of whether you're an originalist, a living constitutionalist, or perhaps some combination of the two. One is that there is a deep contradiction at the heart of the logic of the majority. On the one hand, the majority opinion by Justice Stevens, it says you have a constitutional right not to have your property taken for some purpose that is not a public use. The reason for that right, the purpose of it, is to protect you against the abuses of the government, usually state and local governments. But then who gets to define the scope of that right? Who gets to define what counts as a public use? Well, it's the very entity that the right is supposed to protect you against in the first place. The government, so long as they think something will create a public benefit, under the Kelo majority, pretty much always, with rare exceptions, the courts will defer to them. And this doesn't make a lot of sense. There is no other part of the Bill of Rights that is interpreted in such a way that the very government entity that the right is supposed to protect you against is the very one that gets to define the scope of the right. It's kind of like saying, we have a problem with chickens being stolen from chicken coops. We need to create a group that will decide what the rules of access to chicken coops will be. So who will we choose to do that? Well, we're going to appoint a committee of wolves. They will get to decide who gets to go into the chicken coop and who doesn't. Obviously, what's going to happen is that the chickens will be stolen and eaten, and that's pretty much what happens when you leave the determination of what counts as a public use up to the very entities that are supposed to be constrained by it. Another problem with the Kelo decision, I think, cuts across methodological lines is their misinterpretation of precedent. In a famous passage in the majority opinion, Justice Stevens writes that the broad interpretation of public use that he adopts is supported by a century of precedent. Now, as I noted before, it is indeed supported by precedent going back to Berman versus Parker in the 1950s. But when Justice Stevens refers to a century of precedent, he's citing cases from the 1890s and early 1900s that were not even public use cases at all. What they actually were is cases where people were trying to challenge state government or local government takings in a federal court using the due process clause of the 14th Amendment under the so-called substantive due process doctrine of the Lochner era. And under the due process clause, it is indeed the case that the Supreme Court was relatively deferential to the government during this era, though not as deferential as in cases like Kelo or Berman versus Parker later. But they weren't actually public use cases, and so you might wonder why were people bringing these cases under the due process clause when the public use clause would have been more useful to them. The answer is that at this time, the Supreme Court had not yet recognized that the Fifth Amendment and the Bill of Rights generally apply against state governments as well as the federal government. So if you wanted to challenge a state taking in federal court, your only option was to use the due process clause. So that's what people did. But in the rare cases that actually did involve the public use clause, that they were takings by the federal government, the court made clear that there would be a higher level of scrutiny, particularly takings that transferred property to private interest groups or individuals. So to his credit, Justice Stevens, in a speech that he gave a few years ago after he retired from the court, he has actually admitted that he made a mistake on this point. He calls it an embarrassing to acknowledge error. There are actually not very many major controversial Supreme Court decisions where even the author of the majority opinion has admitted that his conclusion was in part based on a serious mistake. He does still believe that he got the bottom line correct, but on grounds that are actually very different from those that he used in his opinion for the court. We can talk about them in the question and answer session if people are interested, but it's notable that even the author of the majority opinion actually admits that there was at least one serious problem with it. So at this point, I'd like to shift gears a little bit from legal theory and constitutional law and talk a bit about the harmful effects of these sorts of takings on the ground, the damage that they inflict on real-world people and real-world communities. One big problem with the sorts of economic development takings that are authorized by the Kelo decision is they create numerous opportunities for interest group capture of the political process. Pretty much any private business interest can say, if you take away property from this person and give it to us, we might be able to produce more economic development, especially if they don't actually have to prove that the supposed economic development is really going to materialize. And indeed, as I mentioned earlier, there's a long history of these kinds of takings, of benefiting the politically powerful interest groups at the expense of the poor and politically weak. Moreover, often the supposed benefits they're taking are inflated, and the taking ends up destroying more economic value than it creates. Now you might say the political process will take care of this problem. If the voters see harmful or inefficient takings going on, what they'll do is they'll notice this and they'll vote out the politicians who do this. They'll vote out the bastards, so to speak, and then vote in a different set of bastards who will know that they shouldn't do this sort of thing anymore. The problem is that in most cases, the voters have little ability to understand what is going on here. As I discussed in my other book that Professor Yonai mentioned, often the voters pay very little attention to political issues generally. They often don't know even very basic facts. And they particularly don't keep track of relatively complex issues, such as trying to figure out whether these sorts of takings are actually likely to be efficient or not. Indeed, in many cases, the true results of one of these takings isn't even evident until years after the condemnation has occurred. And by that point, quite understandably, public attention is usually moved on to other issues. There are very few elections that are decided by the results of a taking that occurred 5 or 10 years previously. Most of the people, understandably, are focused on more contemporary issues may go to the ballot box. So in most cases, the political constraints on these sorts of harmful takings are actually quite weak, and it's no surprise that many abuses take place. Now, I do readily admit that there is in some cases a potentially serious economic rationale for these sorts of takings, the so-called holdout problem. The idea is that sometimes, unlike in the Kelo case, you have a genuinely valuable project. Let's say it creates $1 million of extra value over what existed before with the previous use of the land. But in order to make the project happen, you have to acquire property from 100 different owners. So you got to go around and buy them out. But when you start doing that, the owner might say to you, well, I'm happy to sell you my land for your wonderful development project, but you've got to pay me at least $950,000. That will leave $50,000 of profit left over for you, so it'll still be a good deal. Now, obviously, if you concede this sort of demand, pretty soon other owners that you need to buy out will make similar demands, and either you have to give up your project or you have to pay more for it than it is worth. So the advocates of economic development takings, what they say is that we need to use eminent domain to prevent these kinds of strategic holdouts from hijacking the process and prevent beneficial projects from being built. Otherwise, you might end up with situations like this one in China, where you have a house that's in the middle of a road that they were trying to build, and obviously the road isn't as efficient or effective as it would be if they were able to clear out this house, and then the entire thing could be used for a roadway. So they say you've got to have eminent domain to prevent this sort of situation from arising. As I said before, this argument does have some merit, but it is greatly overblown. And this is true for several reasons. One is that in the real world, there's no reason to expect that these sorts of takings will tend to be driven by objective economic calculations about holdout problems, as opposed to simply imbalances of political power between those who benefit and those who lose their property to this sort of thing. Moreover, with modern building techniques, it is often very possible to build around individual holdout, so it's actually unusual that one or a few people refusing to sell will block the project entirely. If you're interested in this subject, there are many books which have interesting pictures of architectural holdouts, sole individual owners that were left in place even though a project was built around them. And some people say, well, this shows we got to have eminent domain to prevent this. I say it shows the exact opposite. Each and every one of those projects was built despite the fact that some owners continue to hold out. That's a sign they didn't really need to buy every single square foot of property in this area in the first place. Finally, even in cases where there is a genuine risk of a holdout and you really do need every square inch, often private sector developers have their own mechanisms for getting around the problem without having to resort to eminent domain. There are several such mechanisms, but the most commonly used one is secret assembly. People can only try to be strategic holdouts if they know that a major development project is going on in the area, which must assemble many properties. So what developers do is they begin buying up the property using agents who don't tell the owners what the purpose of the project actually is. And you might say this will never work, the news will leak out. But in reality, developers have successfully used this on many occasions. Indeed, this is how the Disney Corporation successfully acquired the land they needed to build Disney World right here in Florida. Even though Disney is very much in the public eye and the media closely follows what they do, they were able to do this, and this is much easier actually for less high-profile developers to carry out. So I don't contend that if you adopt the sorts of rules they advocate, there will be no good takings that are ever blocked. Protecting this constitutional right is not a completely free lunch, but it's a very cheap lunch in the sense that you get a lot of food, a lot of economic and other benefit and on the other hand, there's only a relatively small cost because only a few good projects will be blocked. I would also like to talk briefly about the closely related blight condemnations. They're not quite the same as the economic development takings that you had in the Kelo case, but nonetheless are a similar phenomenon. Indeed, in the 1954 case of Berman versus Parker, when the Supreme Court first endorsed the broad definition of public use, what they did was they actually upheld a blight condemnation. At least in theory, Blight condemnations differ from economic development takings because with a blight condemnation, before you can take the land and give it to a private developer of some kind, you've got to prove that the property in question is actually blighted. So you might want to say to yourself, well, what could be wrong with taking blighted property? There's not many people who are going to come out and say, well, blight is actually good, we need more of it. Most people would probably say you want to diminish the amount of blight rather than increase it. But trying to use eminent domain to do this, it has two sorts of very serious problems. One is that in many states, the definition of blight has become so broad that almost any property qualifies. Such areas as Times Square in New York and downtown Las Vegas have been declared blighted and therefore open for these kinds of condemnations. So that's one problem. There seems to be a slippery slope where the definition of blight expands over time in many places, such that probably your backyard is blighted under that definition, and certainly mine is, so almost any area could be taken. But even in places which are genuinely blighted, where a layperson would go there and say, yes, this is real blight, it's not just blight that only a lawyer could see. Nonetheless, there's a serious problem with destroying the neighborhood for the purpose of saving it from blight. Because what typically happens with these takings is that poor and politically weak people, often ethnic and racial minorities, are condemned. They're forced out of a neighborhood. They're left even worse off than they are before, and the taking often fails to generate as much development as was promised. Indeed, since blight takings first became common in the 1930s and 40s, we have probably forcibly displaced several million people with these kind of condemnations, most of them poor and minorities, fewer in recent decades than at the height of these sorts of takings in the 1950s and 60s, but still a substantial number. So in general, there are better and more humane ways of promoting development in poor and blighted neighborhoods than by simply destroying everything, forcing people out, and trying to rebuild almost from scratch. Indeed, one of the lessons of modern development economics is that property rights are actually extremely useful to development. If you respect them, that increases people's incentives to invest. It also increases their ability to form various social ties that are beneficial to development. When American foreign aid experts give advice to underdeveloped nations about how to grow their economies, one of the most common pieces of advice that is given is that they got to have secure property rights so as to stimulate investment. This is actually very good advice, and we would do well to take it in the less developed and more troubled areas of our own society. So I think while there are rare cases where these sorts of takings can be beneficial, on balance, we derive far greater benefit from banning them than we lose potentially from eliminating the few good takings, the few good projects that are facilitated by them that couldn't exist otherwise. At this point, I'd like to talk a bit about the ideas of some scholars and reformers who say, yes, I agree, there are serious problems with these kind of takings, but you can solve them without banning them entirely. So maybe we can have our cake and eat it, we can have the good takings, but we can somehow mitigate the harm done by the bad ones. And the most common idea of this sort is the idea of increasing compensation. Maybe the problem is that the owners of the property that is taken, they don't get compensated as much as they should, so if we increase the compensation, they will be just as well off as they would have been had their property never been taken in the first place, and therefore this can solve the problem. I do in fact agree that in many cases the compensation is inadequate and it would be desirable to increase it, but there are a couple of serious problems with this reform project, ones which ensure that it's unlikely to fully address the issue. One is that when you look at how to compensate people, it turns out to be very difficult to fully compensate them for their losses. The usual formula now that the Supreme Court requires is fair market value compensation, which is the value that your land would have if it was put up on the open market. But many people actually value their property at a higher level than fair market value. That's why they tend to hold on to it. Think of, for instance, homeowners who live in the same place for a long time and have social ties, or small businesses who derive a lot of value from their connections to customers in the area. They have what economists call subjective value. a value that they attach to property over and above its value on the market. But it turns out that it's very difficult for the government to properly estimate the subjective value, so if they start trying to compensate people for it, most of the time they will either still undercompensate them because they haven't put a high enough estimate of subjective value, or they might overcompensate them, and overcompensation is itself problematic because if you start overcompensating people, then people actually start lobbying to have their property condemned. At that point, you really will have the Donald Trumps of the world lobbying state and local governments saying, please take my hotel so that I can get the extra compensation. And that also, for obvious reasons, is not something that you want to see. Moreover, even if you get the compensation formula perfectly right, if you had sort of the omniscient government that can perfectly estimate each person's subjective value, or say maybe God comes along and he estimates the compensation amounts, you're still going to have a problem because the owners of the condemned property are not the only victims of these takings. As noted before, often these sorts of takings undermine the security of property rights and destroy economic value for the community. And so the community as a whole suffers from these sorts of takings. Indeed, the higher the level of compensation, in some ways the more burden there is on the taxpayers, because of course they have to pay more money to compensate the owners more. So while I am in favor of increasing compensation in a variety of situations, I don't think this is a sufficient solution to the problem of eminent domain abuse. Now, there's another group of reformers who say, well, the real problem here is that homes are being taken. That's what led people to sympathize with Suzette Kelo and her fellow property owners in New London. They were losing their homes, and so if we only restrict or ban the taking of homes, or we permit the taking of other kinds of property, speculative property, commercial property, business property, or whatnot, then we can have still good development projects which take advantage of these other sorts of property but will protect homes. I certainly agree that it is desirable to protect homes, but it's also desirable to protect other kinds of uses of property. I mentioned already that small businesses often also have subjective value. Think of a person who has developed a restaurant, for example, at a particular site. He or she has their customer base. Very difficult for them to successfully relocate somewhere else. Or think of churches or schools or other institutions of this kind which have important roots in the community. So there are many other kinds of high subjective value properties. Homes are not the only ones. Even when there isn't much subjective value, we still don't want to disrupt normal economic development and social growth by having the government try to plan these things and transfer the property to politically influential interests. So this too, while it might be an improvement over the status quo in many places, it is not as good as simply protecting all property and not just homes. So one of the most dramatic aspects of the story of Kelo, perhaps the most important in some ways, is not what happened with the case itself, but what happened afterwards. Most Supreme Court decisions, only experts really pay attention to them, or maybe a few people who are directly affected, but this case was a dramatic exception to the rule. Almost immediately, there was a massive public backlash, which cut across the political spectrum. Polls showed that over 80% of the public disapproved of the decision, and this cut across the usual ideological, partisan, racial, and gender lines that often divide us politically. This was a rare case where Rush Limbaugh, the NAACP, and even socialist Bernie Sanders were all on the same side. There are not many issues that unite that disparate group of people, but this was one of them. This decision drew not quite universal condemnation in society. There were some people who did defend the decision, such as Donald Trump, for example, and many of my fellow law professors, but on the whole, public opinion was overwhelmingly opposed to this. And in the aftermath of the decision, 45 states enacted eminent domain reform laws to try to curb these sorts of takings, which is a record. No other Supreme Court decision in all of American history has generated as much state legislation in response to it as this one. It broke the record previously set by the death penalty decisions in the 1970s, where some 35 states reacted by reforming their death penalty so it could be reinstated, and so you could execute people again in a way that the Supreme Court would approve of. this actually broke that record. And many people therefore said, well, this proves that we don't actually need judicial intervention to protect this right. After all, the political process has solved the problem. Justice Stevens, the author of the Kelo opinion, for example, made a speech where he said, I have been vindicated, the political process has taken care of this, there was no need for the Supreme Court or judiciary to step in. And I think there indeed was enormous progress in many states, including actually right here in the state of Florida, which enacted perhaps the single strongest reform in the entire country. So I commend you for doing that. But the amount of progress nationwide was not nearly as great as it might look at first sight, because in many states, indeed in a majority of the states that enacted reforms, the reforms actually provided little or no additional protection for property owners. This was particularly true in those states that enacted reforms through the ordinary legislative process, where the law was ineffective in 22 out of 37 cases. Ineffective not in the sense that it didn't do everything that I might think is desirable, but in the sense that it didn't even provide meaningful protection for these sorts of takings beyond what had existed previously. So while a lot of progress was made, there were many states where the progress only looked like it was being made, but in reality did not occur. So this raises some interesting questions. One, why was there such a big backlash against Kelo in the first place? After all, as I noted earlier, Kelo didn't change previous precedent very much, so people were angry about these kind of takings after Kelo. Why weren't they angry before? Secondly, given the massive public opposition to Kelo, why were there so many ineffective reform laws enacted? You would expect perhaps that the politicians would respond to public opinion in a more thoroughgoing way. Finally, there's an interesting pattern among the post-Kelo reforms. Those enacted by referendum initiative, on average, tend to be much stronger than those enacted through the ordinary political process. So that raised the issue of why. Why was one kind stronger than another? And I think there are many factors that account for these patterns, but a particularly important one is political ignorance. As I noted earlier, most people don't pay much attention to the details of law and public policy, so it's quite understandable that before this highly publicized Supreme Court decision, most ordinary Americans simply had no idea that these sorts of takings were going on. To them, it was like lifting up a rock or shining a light in a corner and seeing, wow, there's a lot of cockroaches here that I didn't know were there before. Cockroach experts might say, well, that's no surprise to me. I always knew that there are cockroaches in these kind of dark places. Much as a lot of my fellow law professors after Kelo, they said, well, nothing to see here. This is just in accordance with the existing doctrine. But unlike the law professors, ordinary people didn't know about the doctrine, so they were genuinely shocked that this was going on, just as you might be shocked if you suddenly discover a large concentration of cockroaches in the corner of your house, even though some expert might say, well, that's not surprising. We always knew that cockroaches like these sorts of places. So I think that helps explain why there was such a big backlash. It also helps explain why much of that political legislation enacted was ineffective. In survey data that I was able to compile in 2007 at the height of the Kelo backlash, I was able to show that some 87% of the public either did not know that their state had enacted a post-Kelo reform law or did not know whether it was likely to be effective or not. And this ignorance, like the hostility to Kelo, cut across partisan, ideological, and other sorts of lines. So it's not surprising that this would be so. Most people don't study the details of post-Kelo reforms or other laws. They can't readily tell the difference between effective laws and ineffective ones. So this created an incentive for politicians to, on the one hand, try to satisfy public opinion by enacting some sort of reform, but on the other hand, enacting relatively weak reforms that would avoid riling up the Donald Trumps of the world and others who benefit from these sorts of takings, who do keep track of the laws and therefore might retaliate politically against politicians who cross them. So I think this helps explain that pattern. It also, I think, helps explain why citizen-initiated referenda were more effective on average than reforms enacted through the ordinary legislative process. it's not because when people vote in a referendum initiative, they're better informed, they keep closer track of issues than when they vote in ordinary elections. It's rather the difference in incentives between those people who write the different types of laws. Referendum initiatives are usually written in this area by property rights activists, people with a very strong commitment to limiting these sorts of takings, and also people who are not running for office themselves and therefore don't care very much if they annoy interest groups. There is an exception to this rule of strong reforms enacted by referenda, but it's an exception that tends to prove the rule rather than invalidate it. It's Proposition 99, enacted in California in 2008. This turned out to be a very weak reform. Who put Proposition 99 on the California ballot in the first place? It was actually the California League of Cities, an organization of local governments, the very entities that wield the power of eminent domain in the first place. So it was understandable that they didn't want to sponsor an initiative that would actually curtail their own powers. You might wonder, why did they even bother to put an initiative on the ballot in the first place, given that they liked the status quo? The answer is that they did it to counter Proposition 98, which was on the ballot at the same time. It was an initiative sponsored by property rights activists that really would have constrained these sorts of takings. Prop 99 even included a provision that would negate Proposition 98 if both were enacted, so it was a kind of Trojan horse intended to prevent real reform. As it turned out, Prop 98 actually was defeated outright by the voters because it included other provisions that were less popular than eminent domain reform, but the California League of Cities didn't know that that was going to happen, so they decided it was better to be safe than to be sorry. So overall, I think there has been major progress in post-Kelo reform in many states, just not as much progress as we would expect, not as much as we might want. So there still is a role for judicial intervention in this area. I should also note that there has been important progress in state Supreme Courts, where several state Supreme Courts since Kelo have repudiated the federal Supreme Court's approach to the federal public use clause in Kelo as a guide to the interpretation of their state constitutional public use clauses. This further shows that there's no longer any consensus in favor of the broad definition of public use. By contrast, when the Supreme Court first adopted the broad definition in Berman versus Parker in the 1950s, in the years after that, numerous state Supreme Courts adopted Berman as a guide to their interpretation of their state constitutions. So on balance, the cause of property rights, I think, is much better off today than it was before Kelo. Losing the Kelo decision actually made it better off because the pre-existing situation was so bad that even losing this high-profile case was better than simply maintaining the status quo in place. But there is still a lot of work to do, a lot of progress that can still be made. So I end with this. This is Willow the Golden Retriever making the case for property rights. It would be a terrible shame if her home was condemned and transferred to private parties so as to create a shelter for feral cats. Thank you very much, and I really look forward to your questions.